Hello, welcome to this latest in our series of webinars here at George Washington University Law School at the Government Procurement Law Program. I'm Chris Eukins. I'm the Lynn David Research Professor of Government Procurement Law here at GW, and I want to welcome you to this webinar on U.S. bid protest, progress and reform. It's going to be a very interesting webinar because there are so many protest reform proposals pending before Congress and elsewhere here in Washington. So I'm really glad that we could pull this together, pull this webinar together, and have such an outstanding panel join us as well. Um, the recording from today's program will be available later today at publicprocurementinternational.com. There are extensive program materials available there as well. If you just click through, look for the webinar in the upper left-hand corner of that page, and you'll click through to the program page. We also will be posting the video at the GW Law Government Procurement Law Program YouTube page where we have our other webinars posted as well. There will be a podcast produced from this in the coming weeks. In the program, we're starting a series of podcasts, and this webinar will be distilled down to a podcast as well. During the course of the session, if you have questions, please feel free to use the Q&A function, and we'll be responding to the Q&A and, if possible, to the chats as well. I want to stress that the speakers' statements today are in their personal capacities, and the Chatham House rule applies. So I'm going to give you a quick overview of the panelists, and we're going to move to the heart of the program. We're going to have a presentation on the Section 885 report from GAO. We're going to discuss various reform proposals under consideration, and then we're going to turn to the Percipient.ai decisions, especially the last one from the Federal Circuit. Our speakers today are Ken Patton, who's the Managing Associate General Counsel at the U.S. Government Accountability Office. He'll speak to GAO's Section 885 report to Congress on proposed bid protest reforms. He oversees GAO's bid protest function and is responsible for leading and managing the attorneys and administrative staff responsible for resolving bid protests at GAO. We also have Judge Marion Blank-Horn, who was appointed by the President and confirmed by the United States Senate as a judge of the U.S. Court of Federal Claims in 1986 and again in 2003. She's a graduate of Barnard College at Columbia University and received a JD degree from the Fordham University School of Law. She's a professorial lecturer in law at GW Law School. We're also joined by Dana Chase, who's the Chief Trial Attorney in the U.S. Army Legal Services Agency at Fort Belvoir in Virginia. She's a professorial lecturer in law at GW Law as well. She directs a team of trial attorneys in defending the Army in appeals before the Armed Services Board of Contract Appeals and the U.S. Court of Federal Claims, and provides oversight of all bid protests before the Government Accountability Office, U.S. Court of Federal Claims, and the U.S. Court of Appeals for the Federal Circuit. We're joined as well by Scott Flesch, who's a member of the law firm at Miller and Chevalier. He's served for many years as a lecturer at the Catholic University of America's Columbus School of Law. He represents government contractors in high-stakes matters, including bid protests. He previously served as chief trial attorney for the U.S. Army and as chief of bid protests for the U.S. Army's Contract Litigation and Intellectual Property Division. Finally, Brian Goldberg is an attorney with the U.S. Department of Defense who's joining us. He recently received his LLM degree in government procurement law from GW Law School, where he wrote his thesis on the Percipient.ai litigation. With that, I'll turn it over to Ken Patton to discuss the Section 885 report that was delivered by GAO in response to a specific request in last year's National Defense Authorization Act from Congress to GAO.
Thank you, Chris, and good morning, everyone, and good morning to my colleagues, distinguished panelists, and thank you for inviting me to participate in this panel. As Chris mentioned, the National Defense Authorization Act for fiscal year 2025 included a provision, Section 885, for GAO to propose to Congress a process by which a loser at a GAO bid protest could pay the Department of Defense and the potential awardee its lost profits. This was a pretty unique provision in that Congress typically does not ask GAO for a legislative proposal, but in this instance, they wanted to see what our views were with regard to a loser pay, which is what this kind of arrangement is typically referred to as. Congress had previously enacted a provision in the 2018 National Defense Authorization Act for fiscal year 2018 for the Department of Defense to create and implement a pilot program to see whether or not loser pay could be a viable alternative to allow the Department of Defense to recoup profits and to discourage frivolous protests from being filed at the Department of Defense, but they subsequently repealed that provision. So 885 was Congress's latest attempt to try to get at a mechanism or manner to discourage frivolous protests from being filed. As you will see from that initial slide, GAO implemented and wrote its proposal and provided it to Congress. There is a link to where it is published on GAO's website for those of you who want to read it. If we can move to the next slide. So what did 885 require? First, 885 required GAO to develop an enhanced pleading process for those who are interested in participating in the bid protest process. It also required, if we go, yeah, there we go. It also required GAO to develop benchmarks. And these benchmarks were to capture the costs for the Department of Defense to resolve and manage a GAO bid protest. And also it was to capture the costs for lost profits for the awardee of who was involved in a GAO bid protest. And lastly, it required GAO to develop a process to recoup the lost profits and costs for the Department of Defense utilizing the benchmarks that GAO was to develop. Next slide. So let's talk a little bit about some of the statistics that involve that the Department of Defense has with GAO in GAO bid protests. As you can see from this chart, it's a 10-year snapshot of the number of protests for government-wide procurements at the government protests at the Government Accountability Office and DoD. The top number represents the government-wide, and the shaded numbers represent the number of DoD procurements. As you can see over this chart, over the 10-year period, the number of protests at GAO from the Department of Defense and from the government has steadily declined in the last 10 years. And GAO has a number of theories as to why that might have taken place. One of the theories that we think probably has impacted the Department of Defense most significantly is in 2018, Congress required the Department of Defense to create what are called enhanced debriefing processes. And these processes required the Department of Defense to provide more information to losing offerors about why they lost, why they didn't win the contract. And one theory is that with more information, companies decided that they had the information they needed to do better the next time, and they didn't need to file a big protest in order to obtain that additional information. There are other theories about why contractors may have decided not to protest, but again, it's very difficult to understand why a company makes a business decision to decide not to file a protest. There's no real data that's out there. The most that we can do is perhaps come up with some theories. One of the other theories that we had with respect to why procurement protests have declined is that Congress has also raised the dollar threshold for when companies may file protests of task and delivery orders from the Department of Defense. Currently, that threshold is 35 million, meaning that in order to file a bid protest at GAO, your procurement has to have a value in excess of 35 million. So that's going to cut out a number of procurements that are below that threshold. So that's, again, another theory as to why bid protests from the Department of Defense may have declined over this 10-year period. As you can see from the bottom of this chart, we also, in coordination with the Department of Defense, identified the number of procurements that GOD enacted from 2020 to 2024, which, as you can see, was about 144,000. Out of those, there were 2,300 the protest filed at GAO, which represented about 1.5%. So as you can see, a very small number of the overall number of procurements that DoD enacted over that 4-year period were actually protested at GAO. Next slide. So let's get into a little more of the details about the enhanced pleading standard. GAO's regulations require that a bid protest set forth very detailed and factually accurate indicia of a protest. And if you don't provide that information, GAO is likely to dismiss your protest, meaning we will get rid of it and not consider any of the merits. Congress, in asking us to provide for an enhanced pleading standard, asked us to provide a standard that might have made it a little more challenging for protesters to file a protest. And the theory behind this was that perhaps there were companies that were filing protests that were meritless. And Congress wanted to see if there was a way to raise that bar, raise that threshold to make it a little more challenging. Or in other words, to make sure that if you're going to file a protest, that your grounds were factual, accurate, and had some valid bases. GAO looked at its pleading standards, and we discovered that while our regulations provided for very clear standards that we would apply in protest, our decisions sometimes created some ambiguity as to what type of protest you needed to file in order to withstand being dismissed. We had articulated a standard that said allegations or evidence would be sufficient to withstand a GAO request for dismissal of your protest, implying that you could either plead allegations or you could either plead evidence. One or the other was sufficient. In practice, what we typically said was that speculative allegations were not sufficient. And in essence, we are sort of saying something out of the two sides of our mouth. So what we decided to do was in response to Section 885, we were going to clarify what our pleading standard is, and that standard now stands. You've got to allege credible allegations that are supported by evidence and are sufficient, if uncontradicted, to establish the likelihood of the protester's claim of improper agency action. So we're focusing more on making sure the allegations are credible rather than giving people an alternative to think about whether or not the allegations or evidence. That standard has been articulated in the case that you see at the bottom of that slide, Warfighter-Focused Logistics, and it is a standard that GAO will use moving forward with regard to pleading. Next slide. The benchmarks. So in order to make this process easier for the Department of Defense, Section 885 envisioned a chart of benchmarks based upon the value of the procurement and the cost that DoD utilized to defend in a particular protest. So in other words, you might have a chart for $5,000 procurement, DoD spends X, $10,000 procurement, DoD expends X plus one, and so forth and so on. That way, the department could look at the costs and say, oh, this procurement was $1 million, so we would likely have X amount of costs. That would be the cost that you would need to reimburse the Department of Defense. In order to create such a benchmark, however, GAO and the Department of Defense needed to examine the procurements and the protests that the department defended against to find out what those costs were. As we and those costs included things like costs for counsel, the contracting officer, program official costs. They also included contract delays, the cost of awarding interim contracts. And so as we engaged with the Department of Defense to ask them what was the data behind some of these particular points, we discovered, and DoD probably already knew, they didn't capture these kinds of costs. particularly because there was no statutory requirement for them to do so. When we looked at the totality of the number of costs that DoD had, when we looked at the number of procurements that DoD had, as I previously mentioned, we found that the number of protests at GAO was only 1.5%. And so from their perspective, it really didn't make a lot of business sense for them to attempt to capture these kinds of costs for a very, very small number of procurements. Next slide. Section 885 also required GAO and DoD to attempt to capture the lost profits for the awardee that were the awardee might have earned during the pendency of a GAO bid protest. As some of you may or may not know, when a company files a bid protest at GAO within certain timeframes, the agency's procurement is automatically stayed. That means that the agency can't move forward with performance of that contract. So this section really wanted GAO and DoD to determine what the anticipated profits that a contractor might have earned during the pendency of that pause on the performance of the contract. Again, we engaged with the Department of Defense, and we also engaged with the number of private sector organizations to find out what costs or profits they might have earned during the pendency of a GAO bid protest. And not a lot of them, I would virtually say none of them wanted to provide that type of information. They cited proprietary sensitivity concerns. They also cited the fact that they weren't required to provide that information to the Department of Defense. And so, again, the private sector entities didn't want to provide it, and the Department of Defense didn't collect it. So that information, again, was unavailable for GAO to develop the type of benchmarks that were envisioned by Section 885. Next slide. So what did all that mean? At the end of the day, Section 885 created a regime envisioning benchmarks that would peg costs for DoD and lost profits to the value of a particular procurement. Well, none of that information is maintained by the Department of Defense. None of that information is provided to the Department of Defense by the private sector. So the benchmarks as envisioned by Section 885 couldn't be developed. However, that wasn't the end of the story for GAO. We provided Congress with some alternatives. And the first alternative would have been to require the Department of Defense by statute to enact a contract provision that would allow the department to file a government claim to recoup lost profits in the event that GAO dismissed a protest because it lacked a legal or factual basis. The second alternative, now that alternative would also require or give the department some discretion as to whether or not to file a claim. So it wouldn't be an automatic, because a government claim is an affirmative action that the department would have to take. This, we thought, would give the department some discretion to go after those contractors that the department thought were particularly egregious, or that they thought that their protests were really meritless. So they wouldn't have to do it all the time, but in those instances where they thought it was a problem, they could file a government claim. The second alternative would have been for the Congress to provide GAO with the authority to make recommendations with regard to lost profits. We thought this second recommendation would be particularly challenging to implement at GAO. One, because of GAO's placement in the government. GAO is part of the legislative branch of government. We don't have the authority to mandate or require the executive branch to do anything. We only make recommendations. The second concern with regard to require or authorizing GAO to make recommendations here was that GAO doesn't have any authority over the private sector. And so how would you implement a process for a loser to actually pay the government and the awardee, it's lost profits, remains to be seen. It would require some additional analyses and thought as to how to make something like that work. One final footnote I will say is that the first option has somewhat been adopted by the the House version of the National Defense Authorization Act for fiscal year 2026, Section 818, includes a provision that would require the Department of Defense to create a defense federal acquisition regulation clause to sort of implement this first option here. So with that, I'm going to turn it over to my colleague, Chris, to take us further.
Thank you very much, Ken. So in this portion of the program, we'll be discussing various reform proposals. A number of these were reviewed in a subcommittee meeting in the House Government Operations Subcommittee on July 22nd. You can see our own Ken Patton there was on the panel with me and with Zach Prince. And we took a lot of interesting questions from members of the House Subcommittee. And again, a lot of their proposals that they wanted to ask us about we'll be discussing in the next few slides. So the first issue is the issue of two-byte protests, and these issues are also discussed in further detail on the program page as well, if you like some background materials. So this issue of two-byte protest or two-bite at the apple, to use the phrase in English, this is where if a protest can be brought originally at GAO, and then if it's lost, it'll be brought again for a second bite at the apple, so to speak, at the Court of Federal Claims. And these have been controversial because essentially the same protest is being litigated twice, but as you'll hear now in our discussion, in practice, oftentimes the way that the protests are heard and decided as literature on the program page discusses can be quite different. So the first question I have is for Dana. Dana, are these types of two-byte protests, are they burdensome for the agencies?
Morning, and thank you for having me. Yes, they can be burdensome for the agency because the record at GAO is limited to the relevant issues of the protests brought up by the protester, whereas at the Court of Federal Claims, the record is much larger. So in a relatively short timeline, the agency has to gather up all the documents for the record to present it at the Court of Federal Claims. So everything having to do with the solicitation and the offerors, everything goes into that record. So it's a large record to gather in a short period of time. It has to be reviewed. The contracting officer has to certify it. And then also at the same time, there's considerations for the agency. While the protest was at GAO, there could have been a SECA stay. Do they want to continue the stay? Do they want to they want to move forward with contract awards? So they're also trying to juggle that at the same time. So there's a lot that is burdensome for their agency when you have a two-byte protest. But the idea is you have to balance that with issues that the protester identifies and is trying to seek resolution. So it's, the balance of the integrity of the system with these two-byte protests.
Thank you, Dan. Scott, are these two-byte protests, are they necessary to ensure a full administrative record?
Sometimes. So I think it truly depends whether or not you're in a pre-award or post-award stage, because the relevant record will be very different. And you can have a pre-award protest attacking a solicitation that carries on to a post-award stage, in fact, if there's no stay on performance. So it varies per procurement and per protest of what a full administrative record really should look like. But yes, I mean, the premise that you get a different record and that it may be necessary to carry on a protest to the Court of Federal Claims is a very real consideration for government contractors because, as Dana said, you're only going to get the directly relevant records at GAO, and relevancy is tied to the specific grounds raised. And so if you're only attacking the evaluation of your own proposal, you're probably not going to get the evaluations or the proposals of your competitors. Whereas at the Court of Federal Claims, they have a very more fulsome, transparent approach, and the record may include all proposals or all evaluation records, whether it's a pre-award or post-award protest, a pre-award that carries over. That record can be pretty fulsome. So that helps, especially when we get to the briefings later on. We'll talk about, contractors just wanting more information. And sometimes it's necessary to get a more fulsome look at that record to go to the Court of Federal Claims and take that, second bite, or really, honestly, a new bite sometimes, because there really are new protests with new records and potentially even new issues.
Thanks, Scott. So for folks who are outside the U.S. government system and thinking about the models here, just to clarify what Dana was saying, as both Dana and Scott alluded to, the GAO protest rules call for the agency to produce relevant documents, while the Court of Federal Claims rules, and they're linked on the program page, the Court of Federal Claims rules in Appendix C actually list the elements as a detailed list of what from the administrative record has to be produced. And that's why these different sets of rules produce different records, as Dana and Scott referred to. So, Judge, if I could turn to you, can the Court of Federal Claims, when it gets a second bite protest, can the Court of Federal Claims take the GAO's prior decision as persuasive?
We do generally, although, as you know, when you've dealt with judges, we all do things somewhat differently. So I can speak primarily for myself, but I've been on the court for a long time. So I can also say that at the court here, I think most of our judges do look to the GAO opinion. You have to remember, however, the GAO body of law is somewhat different from the body of law that the Court of Federal Claims looks to, although we are all bound by the Court of Appeals for the Federal Circuit, which is our appellate court. The one thing I do want to add, Chris, to this is that our statistics look a little bit different than the GAO. If we look at our statistics from 2023, they've gone up into 2024 and look like they're going to be about the same as 2024 and 2025. We have a lower number of cases because a lot of the cases do take somewhat longer, and we are the second bite at the apple sometimes, although we can get protests initially without a party going to GAO. So it's a duplicate system in a number of ways. But I think in terms of persuasiveness, absolutely, we look at the Court of Appeals for the Federal Circuit first, then we look at our own decisions, which are also not binding on any of the judges of the court through a quirk in our historical past, so that our own judges are persuasive on each other. And then we look with the same persuasiveness, I think, to the GAO, but we do not have to agree with either. So there's a little bit of an independent judging here, as is appropriate in the federal system, and we are the resort that then leads to the Federal Circuit, and that creates some differences.
Thank you very much, Judge. So the next issue is perhaps the most controversial, and just for the audience, because this really spooked my fellow panelists when I told them the illustrations we'll be using from here on in, the photographs and the slides, I produced using AI, just using Gemini. That's why you see the symbol in the upper left-hand corner above each of these photos, each of these images took about 20 seconds to generate using AI. So it's really frightening when you begin to realize exactly what you can do with AI in terms of creating images like this. So the reason that protests by incumbents are so controversial is that critics argue that incumbents are using protests. If they lose the follow-on contract, they're just using a protest to stall the follow-on contract so they can continue to gain revenues from the prior contract that they hope to continue using a bridge contract. And that's created a lot of friction within the procurement community, the sense that protests aren't being brought in good faith, but instead are being used simply to extend a revenue stream. Well, my first question to Dana is, are you concerned that incumbents may use protests to stall a follow-on protest? Are there informal means of addressing this?
It may seem that way when an incumbent files a protest, but again, the protester has to file a valid basis for that protest. And there are mechanisms in place to ensure that the protester has valid bases for protest. You had Ken Patton talking about the clarification of the pleading standards. But I also think with regards to informal means of addressing whether it's a mechanism to stall, if you have a robust debriefing with an incumbent that didn't win the follow-on award, that can provide some information to them. Sometimes you have incumbents that have been working on the contract for years, and maybe they just don't write the best proposal this time around. And so to inform them of that at a debriefing is helpful, or even enhanced debriefing can alleviate any concerns that agencies might have that a protest is just a way to prolong the current contract.
So Scott, if I could turn to you, is it possible to identify which incumbents are abusing the process?
Well, Congress has proposed that we try. Mr. Patton has referenced Section 818 of House Resolution 3838. And there's some really interesting nuggets in this proposed provision to the National Defense Authorization Act from the House side. It's not on the Senate side yet. But what we see is a targeted approach that the Secretary of Defense shall revise the DFARS, the Defense Supplement for Federal Acquisition Regulations, within 100 days of enactment of the statute. And it authorizes, the procedure authorizes a contracting officer to file a claim. And that's very interesting because the claim, an affirmative claim, takes this matter, whether or not effectively the incumbent has abused filing a protest at the Government Accountability Office, because that's where it's limited to, and it's limited to incumbents, and taking that protest procedure and moving it over to the Armed Services Board of Contract Appeals, because it's if an affirmative claim by the government, then the notice of appeal has to be filed by the contractor to rebut that. And now you have litigation at the ASBCA or whether or not an incumbent truly have abused the system on an underlying GAO protest. That is new territory. As some of us know, the GSA used to have a Board of Contract Appeals many moons ago that handled protests, the GSBCA, but that was a long time ago. The ASBCA is not in the business of evaluating the merits of an underlying GAO protest, but this legislative proposal puts it at the ASBCA once a claim has been filed. And there's some interesting other nuggets here. In fact, some of the definitions are really particularly interesting. It deals with a decision at a GAO that has been finally determined with respect to a dismissal of a protest. That was not appealed. It is no longer appealable because of the time for the appeal or was appealed in the appeals process for which is completed. Last time I checked, GAO protests are not appealed. There's no provision in the law for it. They're just refiled at the Court of Federal Claims. So how we're going to get through this definitional approach to what qualifies for an affirmative claim to be filed against an incumbent contractor after a GAO protest once it's been dismissed, I don't know. Time's going to tell. But there's another very interesting provision in Section 818 of House Resolution 383 dealing with stays. Stays that are imposed by the operation of law under the Competition Contracting Act once a protest has been notified to the agency within a certain time window, and it stops performance or prevents award if, in fact, it takes effect. And usually you have two mechanisms for a contracting officer in the HCA to invoke an override of that stay, meaning that they can effectively say, no, in the best interest of the United States or because of national security, you can move on with performance or go to fourth reward, and that can be challenged at the Court of Federal Claims as well. However, the provision of Section D under Section 818 says a contracting officer may not determine that immediate performance of a contract is not in the best interest of the United States if it will facilitate the national defense. And so we're rewriting not only the SECA stay provisions and how contracting officers and HCAs, the heads of contracting activities, have the authority to override these stays, but we're also going after incumbents for filing protests that are dismissed, potentially on non-meritorious or, back to the word, abusive grounds. We're going to see how this plays out, whether this gets forth to the final version of the NDAA, but stay tuned. This is certainly interesting territory, especially for incumbents, and may potentially chill the protest process as it relates to incumbent contractors.
Scott, if I could just go follow up on that on Section 818. So the language of Section 818 says that in order to trigger this claims process, seeking disgorgement by the incumbent, the protest has to be dismissed on a final decision by GAO, and it has to lack any reasonable legal or factual basis. Would it be possible for sophisticated counsel to try to get some sort of concurrence by or some kind of statement from GAO during the course of the proceeding that there may arguably be some basis for this protest, thereby cutting off that potential claim? So in essence, does Section 818 favor the sophisticated protester?
That's a great question, Chris. I don't know. I mean, that puts GAO in another particular interesting box of having to evaluate something that another body, the ASPCA, is charged with under the Contract Disputes Act of evaluating, where the GAO is going to put itself in a position of forecasting or telling the ASPCA whether or not, in fact, this should be recoverable or not recoverable. I'm not sure GAO is going to be willing to do that, and I'm not sure Mr. Patton wants to talk about that right now. But we do have. I learned something a long time ago from the movie Spaceballs, one of my favorites. Don't cross the streams, right? Bad things happen. We are crossing protest streams with contract disputes streams, and it usually does not wind up good in the middle. Stay tuned.
Thanks, Scott. So I have a question for you about enhanced debriefings, but as part of that, to make sense of that, I'm gonna go to well, let me take a step back here. So do you think that with regards to this issue of incumbent protest, Scott, do you think that enhanced debriefings would reduce the risk that incumbents might abuse the protest process in order to prolong the revenue stream?
I think enhanced debriefings to the point where they truly are valuable and contain useful information will not only help thwart protests by incumbents, but by other unsuccessful offerors. Information is king. And in my experience outside the government over the last several years, my clients seek information in order to produce a better proposal for the next competition. It is usually not it's not to lock in performance for another couple of months. It is truly to get better. And they try to ask those specific questions in the enhanced debriefing procedures to exact out information that is meaningful and material to enable them to make a better proposal for the government to drive down costs and improve better solutions. So sure, I think enhanced debriefings would help reduce protests by incumbents as long as they're meaningful and contain useful information.
Thank you, Scott. So the next questions go to the question of meritless or purely technical protests. There is a concern on the part of many folks in the Hill that that meritless or purely technical protests are being lodged. You can see that in the back and forth that we had with the House subcommittee and the questions that we were asked on a follow-on basis. Those are on the program page. Um, so, Judge, starting with you, does the Court of Federal Claims have a means to dispose of meritless protests?
Absolutely, we dismiss the case. That's the evaluation that the judge has to do. So I think there are a couple of things here that are really important to point out. First of all, when you get to the Court of Federal Claims, you have to seek an injunction to initiate a stay. So in many cases, there is no injunction issued. In some cases, there are. I'd say the majority of them, it's hard to get an injunctive. You have to prove likelihood of success on the merits. There are typical federal injunctive standards. So once that happens, the government's in a position to go forward if there's no injunction. That means obviously the court has to move with a certain amount of speed, but there's also a lot of experience on the court at this point amongst the judges who I've been here a very long time, but not everybody has been here quite that long. But I also have experience from the executive branch and did both formation, management, contract, and litigation. So we do have expertise to take a look at meritless protests and to dispose of them rather quickly. I think it is something that happens on a pretty regular basis. It's not that easy to get a protest that goes through the court successfully, especially if it seems meritless. And in terms of seeing people who are using the process improperly, we get to know most of the litigators, particularly on the large contracts, which the government is concerned about moving forward to the defense contracts. And we can tell pretty quickly, there are definitely attorneys who file almost anything. What does that do to a judge? The judge looks very much more closely at that protest, and they tend to be unsuccessful. So I think the system works, and I think there certainly is a way for the government to go forward in a lot of protests. At the Court of Federal Claim, there's no automatic stay. You literally have to go through the injunctive standards, which are pretty tough. And it's a balancing of the equities in a sense. It's the future of success. These are tough standards. And the government can prove that the balance, for example, of going forward with, as opposed to a stay, makes a difference.
And Judge, we don't think you've been there for a very long time. We think of you as a pillar to a very successful institution. So thank you.
Well, that's kind.
So Scott, one of the things that you see over and over again in the policy discussions and the legislative proposals is a working assumption that a protest that loses must be meritless. Is that a fair assumption? Are all losing protests, should we consider them all meritless?
No. And you have to also look at it from a FOIA perspective. So think of this scenario, and I think this can be a nightmare for GAO, is you have a protest at GAO that raises certain grounds based upon credible evidence at the time, and it's more limited in nature. The limited record is produced. GAO denies a protest based upon the record available and marches off to the Court of Federal Claims. The entire acquisition record is produced, and lo and behold, there are records that actually provide merit to the underlying protest grounds. That's not a great scenario. So should all losing protests be considered meritless? No, and you have to look at it in the various fora, the different analysis, and just because it loses and it doesn't meet that standard does not mean it's meritless overall. So no.
Thank you, Scott. So Dana, I want to turn to this issue of AI and I noted in the chat that we're going to be having a session in October on the impact of artificial intelligence or AI on government procurement practice. Just for the record, I seasoned this when I was able to write a protest in less than 20 minutes using AI. That genuinely shocked me that I was able to do that. So there's going to be more protests potentially using AI. Are problematic protests a bigger problem with the dawn of this artificial intelligence, the driving protests, Dana?
We're certainly, at least in my office, we're seeing an increase in the use of AI large language models to either generate protests, discuss cases that may not exist. So it's called AI hallucinations. And it's typically more with pro se protesters. So where with pro se protesters, we would get a 2 to 3 page protest with issues that we could address, we could identify, a little bit easier to respond to and gather the record for. We're now getting like 25, 50 pages or more protests that appear to be AI generated. And when you dig into them, you see maybe facts are hallucinated, cases are hallucinated, and sometimes it's like AI run amok, and it hasn't been checked by the protester. So we're seeing an increase in that. But GAO recently had a decision called the Already decision. Let me see, it was Already LLC. It was issued on the 13th of August of 2025. The B number, and I'll put it into the chat, is B423524.2. So GAO has already addressed this issue of AI and hallucinations in AI. I just think we're going to see more of it and more decisions with regards to people that are not checking their work and submitting work product that has AI hallucinations in it.
Thank you very much, Dana. So the next question has to do with a bonding requirement. This is a suggestion that protesters should post a bond if the procurement is to be stayed pending the protest. So one of the peculiarities of U.S. federal practice is that the contractors are they're fighting for the opportunity to bid to compete for a contract after the protest is sustained, or the agency takes corrective action and reopens the competition. In other systems, such as in England, the protesters are actually fighting for damages potentially, so it's a different kind of fight. But in our system, where the real prize is getting a chance to recompete, as opposed to getting any sort of damages, the stay of the contract that was awarded in post-award protest is really important because that's the only prize available to the protester. So the question is whether or not a bonding requirement should be put in place so that the protester comes it'll really be to GAO should GAO using a model like the Court of Federal Claims does under Rule 65C of the Court of Federal Claims rules, should the protester be required to post a bond to compensate the agency and potentially the awardee for any costs incurred as a result of the protest, if the protest is found to be meritless. And so the starting point here, of course, is the established practice under Rule 65C of the Court of Federal Claims, and that's discussed in some detail at the program page. So the first question I have is for the judge. Judge, how commonly are bonds required in Court of Federal Claims protests?
Not very commonly. There are some times that you do it. Certainly, if you think that it's meritless, maybe you might do it, but it isn't typically done. It is a tool available. It's a discretionary tool available to the judge. So the judge has the discretion to issue a bond and also how much to issue that bond for. If we see AI really taking over in a way that Ms. Chase suggests, we do have some weapons other than just the bond. So we can refer that attorney to a member of his or her bar they are all barred at the state level in this country. And so we've done, threatened it, done it. It's not common yet, but, and we can certainly think about, and we are thinking about double checking briefs much more differently than we did in the past for AI. If you have experience in this field, you can spot it a mile off very often, and then would take some action. That becomes a very serious issue for an attorney who's done it, because that could lead to disbarment and not being allowed to practice. So there are some tools other than bonds as well. Will we increase the use of bonds? I don't know. It's something we talk about periodically. But again, it's left up to the individual judge. So it's there, it's in the rules. The rules are a little bit unclear as to whether you have to do a bond. But remember, if we issued bonds, we would have to take more time to establish not only whether a bond was appropriate, but also whether in what amount to make that bond appropriate. And that will add time to the process potentially, because we can't just willy-nilly kind of pull it out of our mind without thinking about it. And we can't just say, well, your bond is going to be 20 this or 40 this. We have to justify why we've done it.
Thank you, Judge. And on the program page, I listed a number of the precedents where the court has addressed that question over the last 25 years or so. And just for the audience, there have been roughly speaking, there's only been one bond decision per year for the 25 years or so that the court has had this bid protest jurisdiction under the Tucker Act.
Well, Chris, if I could, I think that's not necessarily reflective of how many bonds necessarily, because you're generally not going to get a decision on the issuance of a bond. There have definitely been bonds issued that do not get reflected in a reported decision.
If I could just quickly, thank you, Judge. Just quickly to Dana, I have a quick technical question for you before we turn to the substantive second question. Dana, is there a way that are there electronic tools or online tools that one could use to check for AI hallucinations in a brief?
Yes, there are commercial programs that can check for AI hallucinations. Westlaw has capability to do that. Lexis has capability to do that. There are other companies that will also check for AI hallucinations in documents.
So if I could ask you the substantive question, Dana, would it be easier, and this is for Scott as well, and perhaps Dana wants to go first, would it be easy to institute a bonding requirement at GAO?
It would be very difficult because the contracting officer would have to figure out what it's going to be worth for a bond, figure out the percentage of the bond, the mechanisms for the bond. I'm not sure if GAO can do it fiscally or fiscal law wise. So it would just be really difficult for the agency to figure out a bonding requirement at
Why
GAO.
would there be fiscal law issues?
Um, well, at least for I'm thinking about augmentation of funds, and I'm not sure what would happen if the bond how would it go to the agency? Would it be an unlawful augmentation of funds? There'd have to be a bunch of statutes and things put in place for it. So,
Chris, there's also
Well,
just a practical concern here. I mean, in my experience, and I think that maybe the judge could concur on this one, agencies have a very difficult time articulating, quantifying the damage that a court-imposed stay creates. You could look at potentially the increased funds that are going to be necessary to keep a bridge contract in place because maybe the new contract is cheaper. But the reality is that's extremely difficult. And moreover, it's just there's no infrastructure within the government to quantify the amount that it's costing the government because they're mostly sunk costs. There's no excess salaries. There's usually no overtime. It's hard to quantify it.
thank you both. So I apologize. It looks like we're going to go a little bit over the 60-minute target, but we do have a lot of substantive questions still to address. So we may go for let's say 10 or 15 minutes over our target 60 minutes. So the next is that there have been proposals for consistent timelines and protests. GAO and the Court of Federal Claims and agents level bid protests can be done on very different timelines. Scott, do you think that all protest forums should have consistent timelines?
If the rules and the different approaches to protest and the different approaches to the administrative records stay in place, they should have different timelines. They are very different. GAO is generally viewed by the government contractor community as a more express, expedient option. It is viewed as a mechanism to protect the immediate status quo without having to get a court ruling via the automatic stay provisions. And that accelerates the process where the agency has to produce that record within 30 days. Of course, if there's a TRO at the court, that can be extremely fast, sometimes even faster than producing the record at GAO. But they're different fora, and contractors right now have options, and options are good. They can choose to go down one path and then the other at the court if it's not a task order. And maybe, Chris, you can mention that as well, just task orders are treated differently. But they should have different timelines if the fora are different.
Thanks very much. And just a technical comment. So we've been getting some comments, some raised hands. If the folks who are raising their hands, if you could post your comments in the chat, be very grateful. It's easy to do with that. And some folks have been posting excellent questions to just the hosts. If you could repost those to everyone, the everyone chat then becomes part of the archive that I'll be posting to the program page. And becomes a very good research resource for the future. So, Judge, the question I have for you is, would a regular protest, there's no regularized protest timeline in Appendix C to the Court of Federal Claims rules. Each judge is left with discretion to set a scheduling order for individual protest. Would a regular protest timeline like GAO's work at the Court of Federal Claims?
I think it might be difficult, in part by the nature of contracts that we're seeing being protested at the moment. The government has developed a three-stage protest package, for instance, for longer timelines. The contract lasts longer. The numbers are in the billions in some cases. They're very large numbers. If it's a 10-year contract, for instance, the projection is pretty big. And you can actually protest each stage of a three-stage procurement. And yet we are timelined by the whole case. So there's a very large difference in the kinds of cases. We do have our own internal sort of sets of timelines, and we try to keep all the judges to it internally. But it really depends on the case. The administrative records in some of our cases are ginormous. If you have 70 protesters, as I have in over 70 in one case, you're not going to get to the evaluation stage with all 70, obviously, but that means 3 times 70 potential protests in a single case. So I think you have to be reflective of the nature of the cases that come to the court. We get some small ones, but mostly big ones because of the GAO opportunity at the front end. And I think, we try very hard. Most of our judges will set very early hearings in protest cases to try to figure it out. And as Professor Yukon said, in a TRO, we move very quickly. I think there's pressure on us internally as judges to keep it moving, and we understand the nature of why that is important, particularly in defense contracts. So I find it very difficult, I think, to have 100-day in every case. Now, do we get done with cases in 100 days? Yes, we do. But it depends entirely on the difference of the cases.
Thank you, Judge. So the next question goes to enhanced debriefings, and by the way, this is another actually really interesting example of using AI, because this is completely created by AI. Well, it looks very, very genuine. So the first question I have is for Dana. So what are the practical obstacles to using enhanced debriefings more broadly, Dana? How could they be used more broadly? See, in this picture here, we see what an enhanced debriefing normally includes, which is a source selection decision that is redacted. What do you think the practical obstacles are, Dana, to using them more broadly?
I think some of the practical obstacles are time to schedule them, and still resolve issues, at least with the contracting officers and trying to move forward with the procurement. Being clear about what information can be obtained at an enhanced debriefing, just being clear about what questions can be asked, what information can be obtained. Scott talked about this, having useful information at an enhanced debriefing on how to make the proposal better solutions to lower costs. And I think there needs to be an understanding from the side of the contractor, the offeror, as to what kinds of questions they should ask at an enhanced debriefing to get the information for what they're looking for. And also on the agency side of don't be afraid of debriefings. Provide the information that will make the issues clearer for the offeror as to why they didn't win that award of that contract. So I think there needs to be balancing there, and that's one of the practical obstacles there is just on both sides. One wants information that they might not get to, and the other side, the agency might be afraid of giving away information that they're not supposed to give. And you have to strike that balance.
Thank you. So, do enhanced debriefings help reduce protests, Scott? And what did the ABA survey tell us? I'm just going to flip to the next page, which has a list of questions from an ABA survey that was done among the ABA bid protest committee members in the ABA public contract law section. If you could talk a little bit about the survey, Scott, and what it tells us about the benefits of debriefings.
Yes, thanks, Chris. The ABA was extremely accommodating in a very short order to get a survey out to its members. So that is limited. That was to government contracts practitioners, lawyers primarily were providing the feedback here. And the results were really not a surprise, at least to me. The general trend of the survey population showed that enhanced debriefings, to the extent they provide meaningful and useful information that are triggered to provide information to improve proposals, were very well received by incumbents and unsuccessful protesters alike. To the extent that the debriefings did not provide any information, this was an interesting note. A few survey responders suggested it actually may increase the risk of a protest because it almost appeared as if agencies were withholding information purposely. So the takeaways from those questions related to enhanced debriefings, whether they reduce protests, is more information, accurate information, material information, and useful information to offerors, yes, will lead to a reduction in protests more likely than not, even amongst incumbents. But if the agencies do not share or appear to be hiding it, it actually increases the likelihood that a contractor is going to protest. for, if not the only reason, is to get more information. Then they feel like they have to protest to get a record, to be told by the agency why they lost or why somebody won, to the extent they can under procurement integrity rules and proprietary sensitive information. So there is that belief that enhanced briefings, to the extent that they're enhanced and extended, and they help put a pause on effectively the protest period that a offeror has to rush down to GAO or the court to do so, mainly for GAO, yeah, that can definitely lead to a reduction, but it's got to be treated seriously by agencies, and the information has to be shared and it has to be meaningful.
Thanks very much. Scott, there's if you could discuss just a little bit about the proposal to make under the Revolutionary Far overhaul to make an enhanced debriefing automatically available to anyone who brings an agent's level bid protest and then brings that agent's level bid protest seeking review at a level above the contracting officer.
Yeah, so there are 3 deviations currently approved by 3 agencies, with the largest one being GSA. And there were some interesting nuggets in the deviations that are implementing the FAR rewrite under FAR Part 33. The couple of things that are, I think, particularly important or noteworthy were that the HCA is required to be immediately notified. And I think that's important because it elevates, once an agency level protest has been filed, to somebody beyond the contracting officer that conducted the procurement to tell the HCA that there is an interest here in via an agency protest in finding out more information and protesting a perceived slight or a violation of procurement statute or regulation. Also, there's a provision in the deviations, and they're the same across the board. They've adopted the model changes that a redacted source selection decision document automatically be provided. And so that is a good movement towards the exchange of useful and transparent information, as long as it's not redacted to the point that it's not useful. And then there is a provision that, in fact, protesters at the agency level will get an opportunity to comment or produce a writing to the agency protest official, so that they have that opportunity for advocacy. So these are all useful, I think, changes across the board to the agency protest process, which should be utilized. But there's something I thought that was missing in the deviations, and we can talk to that very quickly. There's a disparate treatment of task order protests amongst agencies and whether they believe they have the authority to address them. I know firsthand that GSA treats their task order jurisdiction differently than, say, the Army does, or at least half the Army. And that at the agency protest level, whether or not they believe they have the authority to actually even adjudicate an agency level protest. This should be clarified. And I hope that the FAR rewrite or legislation addresses this, because last time I checked, task orders were reined in, the protest thereof, to keep the nature of task orders more efficient, to be quicker. And I thought that agency level protests were meant to do that as well. If you force folks to take task order protests to GAO only, that's not doing a lot to encourage and foster an expedient resolution of task order protest. Why not open up the aperture at the agency level for task order protests as well? That's missing, and I think it needs to be addressed.
Thanks very much. And to a certain extent, I skipped us ahead here, Scott, to discuss agency level bid protests. So as the report was done for the Ministerial Conference of the United States a few years ago, and then I republished that report in the Public Contract Law Journal, laying out, and the point of the report was to say, look, this is what the baseline rule is under FAR 33.103 for agency level bid protests, but a number of the agencies have gone beyond that and have improved the agency level bid protest process. Why not take best practices and bring them together? And in some ways, the Revolutionary Far overhaul, as we've been discussing, reflects that. Brings in, for example, a requirement for enhanced debriefings, or which is a redacted version of the source selection document, if a vendor brings an agency level bid protest. So we're seeing movement in this area. The question I have for you, I guess, Dana, is: are agency level protests a good solution for agencies?
Yes, they are a good solution for agencies. It's a way to address issues at the lowest level, to resolve them quickly, not elevating it to GAO or the Court of Federal Claims and putting together ever more robust records. The Army Materiel Command has an excellent agency level program. And as Scott was talking about with the task orders, they address task orders at the AMC agency level protest in their program. So I think it's a way to keep things at a lower level, not having to escalate it and take additional time by going to GAO or the Court of Federal Claims to resolve issues.
And Dan, the Lieutenant Colonel Bruce Mayhews, an Army officer, wrote a piece in our program and published it through the Army on using the AMC model, the Army Materiel Command model that you've talked about, as a model for the rest of the Defense Department as a way of improving agency level bid protests. So Scott, where we are right now is, as a practical matter, outside counsel will often not recommend agency level bid protests because of the uncertainties. They'll steer clients away towards GAO or the COFC. Do you think agency level protests are worth reforming?
I think they're reforming to standardize them a bit amongst agencies and what they should address. One example is this task order jurisdiction, and setting up a process for higher level review. And that's been mandated under executive order in the past under prior administrations. I do think reforming to the point where it becomes useful and transparent and meaningful is a good thing. But there's certain aspects of it that do need to be addressed, and that task order jurisdiction is just one.
Thanks very much. Do you think that the agency level protests are likely to increase with artificial intelligence, Scott?
They may, but be careful. Just like anything in the use of AI, it has its limitations and may not be advising the writer or user of the AI that you may not be getting a SECA stay if you go to the agency level first. I'm not sure the nuances are built into AI, but the application of a stay under the Competition and Contracting Act may be told or eradicated if you choose to go to the agency level first. Depends on the case and the timing and the agency's rules, but you may lose that stay provision, which is the teeth behind SECA in the GAO protest process.
Thank you, Scott. But we're going to turn now on our last section to discuss the Percipient.ai decisions. With that, I'll turn it over to Brian Goldberg, who, as I mentioned at the outset, actually wrote his thesis on the Percipient.ai decision. So, Brian, I'm very, very glad you could join us.
Thank you, Chris. Good morning, everyone. I'll be talking about Percipient.ai case. Next slide, please. Here's my standard disclaimer. Next slide, please. With the Percipient.ai case, what began as a simple COFC bid protest by a disappointed potential subcontractor eventually became the most significant Federal Circuit opinion clarifying Tucker Act bid protest standing in the last 25 years. In the interest of time, I'll try to keep the factual background really brief. So in January 2021, the National Geospatial Intelligence Agency awarded a single award IDIQ contract called Sapphire with an accompanying initial task order to CACI. And then Percipient.ai demanded that NGA force CACI to incorporate its commercial computer vision software into CACI's developmental solution. And CACI determined that the existing government legacy software already exceeded Percipient's functionality, and so was not necessary. At no point had Percipient submitted an offer to that base IDIQ, teamed with another company to submit such an offer, protested the solicitation before it closed, or protested the award of the IDIQ or initial task order to CACI until 2 years later in January of 2023, when Percipient.ai filed a bid protest at COFC. Now, COFC eventually dismissed that protest based on the task order bar, but it also had previously denied a motion to dismiss based on lack of standing. Following this dismissal, Percipient appealed to the Court of Appeals for the Federal Circuit. Next slide, please. So on appeal, a divided Federal Circuit panel reversed, with the majority finding that Percipient had standing as an interested party, thus expanding the previously understood definition of an interested party beyond an actual or prospective bidder whose direct economic interests would be affected by award of a contract or failure to award the contract. In doing so, the majority distinguished the prior 2001 Federal Circuit AFGE case and found the SECA definition of interested party non-exhaustive. In addition, this original Federal Circuit panel majority declined to apply either blue and gold or the task order bar to Percipient's protest. Percipient had persuaded the Federal Circuit with some novel arguments, including canon against surplusage, downplaying the relevance of interested parties' use in the Brooks Act and SECA, and also something of an instrumentalist policy argument that allowing such standings is the only way to meaningfully enforce that statutory commercial item preference. The original Federal Circuit panel majority thus expanded not just the type of parties that could protest under that third subject matter prong of bid protest jurisdiction, but also when the protests could be brought timing-wise. Judge Clevenger wrote an expansive dissenting opinion noting that such an expansion permitted potential subcontractors for the first time to bring a bid protest. The government petitioned for rehearing en banc, and the petition was granted. And then the question confronting that en banc court was essentially the same as that confronting the AFG court 24 years ago, just with a new fact pattern featuring a disappointed subcontractor plaintiff and also the commercial item preference and subcontracting preferences in general. Next slide, please. So the en banc court upheld the original COFC dismissal, decisively reaffirming the AFGE interpretation of the interested party term and holding that the term applied to disappointed bidders only. Parties that could not qualify as an actual or prospective bidder, including disappointed potential subcontractors like Percipient, could therefore not maintain bid protest standing at the Court of Federal Claims, absent two very rare exceptions. Although the Percipient en banc court arrived at the same conclusion as the AFGE court, it arrived there through a legislative history analysis. It was different in both depth and sometimes substance. So where the AFGE opinion had about 2 pages of supporting analysis to arrive at their conclusion that interested party has essentially the SECA definition, the en banc court gave about 30 pages of legislative history and statutory analysis to say that interested party only has the same meaning as it does in SECA. So there's essentially 2 major changes over AFGE. First, they went a step further in their legislative history analysis using the old soil doctrine, arguing that interested party as a term brought the old soil of its interpretation into ADRA from both SECA and the Brooks Act. And then once they've established that relevancy of SECA and the Brooks Act's legislative history, they looked at both of those to show that Congress had considered and rejected disappointed subcontractor standing when it coined the interested party term for standing in ADRA. So to keep with that old soil farming analogy, the AFG court kind of scratched at the legislative history, topsoil with a shovel, and then the en banc Percipient court brought out a commercial grade plow towed by a massive John Deere tractor. As another substantive difference with AFG, the en banc Percipient opinion omitted the sovereign immunity argument that the AFG court found particularly persuasive, which could be another wider indication of the declining importance of sovereign immunity and statutory interpretation by federal courts. And at a minimum, it calls into question whether federal courts still construe waivers of sovereign immunity narrowly. And also, the court didn't address the arguments considered by the majority that the statutory preference for commercial products and services has some kind of unique status for purposes of standing. And then finally, the en banc court responded to a lot of Percipient's novel arguments not raised by AFGE, particularly the canon against surplusage arguments, noting that previous federal circuit cases finding standing in SECA stay cases and solicitation cancellation cases gave that prong 3 its full meaning without any need to expand interested party. And you can see the RAMCOR Services Group and Distributed Solutions citations in the notes section of the slides for that. And then in applying this kind of new clarified standing test to disappoint potential subcontractors, the court found it decisive that Percipient did not and could not have submitted or and chose not to submit any offer or express interest as a prospective offeror during the initial IDIQ solicitation. Next slide, please. So just one point on the dissent. The dissent really kind of repackaged a lot of the same arguments made by the majority in the original Federal Circuit panel decision. But the kind of theme to all of them is a concern for fairness and opportunity for meaningful judicial review. And the dissent's primary concern is that they didn't really feel that there is the government or primes would self-police this kind of subcontracting preference without the possibility of judicial review via bid protests on behalf of those subcontractors. Next slide, please. So we're kind of all back to where we began with bid protest standing prior to the initial Percipient case. It didn't create really anything new. It just clarified the limits of standing to kind of what the traditional understanding was. A disappointed potential subcontractor wanting to maintain a bid protest is going to need to generally either find a prime that's going to protest a subcontracting preference issue in a solicitation pre-award, or otherwise find another way to qualify as a prospective bidder and challenge pre-award, such as through a teaming arrangement. That's all I have today. Thank you, and back to you.
Thank you very much, Brian. So we're running a little overtime, so I just wanted to give our panelists an opportunity to close out with this, to discuss what they see as the possible next steps in bid protest reform. Ken, I wonder if we could start with you.
Absolutely, Chris. I think the next steps have to be for Congress to obtain additional information from the agencies about what particular issues they're concerned with. The provision for 885 thought to address a perception that contractors were abusing the system, but we don't have any data to substantiate that concern. And as Scott mentioned, there are many places along the spectrum of a bid protest where there could be problems. To the extent that Congress does have some concerns with regard to the bid protest system, it should gather the data to find out if a problem exists and where all along that spectrum the problem may exist. So I see that as really the next area that Congress should probably take a look at.
Thank you very much, Ken. So, Judge, what do you see as the next area?
I think that the importance of access to a federal court is an important thing to keep in mind. I do think the rest of the Percipient opinion was pretty predictable. It was a historical kind of review of where things were and a precedential review. So I don't think that's going to be on these particular issues where things change through the court system. But the court system is looking at, and particularly the Court of Appeals for the Federal Circuit, is looking at some different kinds of things, and I think is open to that. So that's one area of change that's going to come down the line, especially with the review and changes that are going to be proposed for the federal acquisition rules in general. And I think you will find that the courts will have to be very active in interpreting new provisions in the FAR, in the federal acquisition regulations. And so I think there's a lot of change coming. It may come in subtle and perhaps unfortunately too slow changes where there's a need to change. But I think we've set ourselves up for looking into the modern practice of how to do acquisitions and procurements better. I'm optimistic in the system. I've been in the system for a long time. I think it is robust. I think the fundamental values that are in the system will remain. Obviously, Congress has a role to play always in revising how we proceed through executive branch performance and review. But I do think that it is set up for a lot of change in the near future, actually, through the review of the federal acquisition regulations.
Thanks very much, Judge. Dana, what do you see as next steps?
I'm with Judge Horn on this. I think the FAR rewrite is going to cause a lot of examination on reforms of bid protest. And we'll see it once all the new regulations come out with the FAR rewrite. And then additionally, I think we're starting to see some changes with regards to the use of AI. So I think we're going to see where we're trying to catch up with technology in decisions in bid protests.
Thanks very much. And Scott?
Yeah, I'm hoping that the scrutiny that GAO is seeing in certain elements of the administration don't translate to bid protest reforms. The process needs tweaking, not a hatchet. And we have a very good system, as Judge Horn says, that's very robust because it promotes transparency and competition, and sets up a level playing field for offerors. And anything that I think deprives those the desiderata, right? The transparency, the fairness, everything that not undermined, I'm sorry, that supported competition of FAR Part 6 really is the backbone behind the protest process system. And we hope that it doesn't tweak to the point where it literally guts it, because the process works. The 2-4 are very different for a reason. And I'm hoping that we don't see substantial changes over the next 12 months.
Thank you, Scott. Yeah, as I discussed in the articles that are posted through Government Contractor, there are two key purposes in a bid protest system. One is to encourage competitors to come back in the future by treating them fairly, and the second is to identify problems in the system. So the bid protest brings those problems to light. Interestingly, the Revolutionary Fire Overhaul, the purposes that are outlined in the Revolutionary Fire Overhaul echo that, and is very healthy because there has not been a clear statement of purposes before. So one way to measure these various bid protest reforms, and we've been trying to talk through this hour, is how do proposed reforms measure up against those two key purposes, which is to make sure competitors feel like they're being treated fairly, and the second one is to bring problems to light. And agents level bid protests, for example, meet those two purposes very well. So I'm very glad we could have this discussion. Ken, it looks like we've lost Brian. So do you have any final thoughts?
Final thoughts. Well, I think final thoughts would be, I don't think acquisition reform is dead. I think that it's likely going to continue in the near future. And I think that with regard to all the proposed FAR rewrite and policy changes that are coming down the pike, we're likely to see a lot of robust protest decisions coming both from GAO and the court.
Thank you very much. We've gone way over time. Thank you all very much for your patience. Oh, Brian is here. Brian?
Sorry, I just regained contact there. Sorry about that.
No, that's fine. And I was going to ask you about the use of guitars in bid protest decisions, but you could talk about other proposed reforms likely to come down the pike. What do you think, Brian?
I do expect perhaps further ways to strengthen the task order bar through legislative proposals might be one way that Congress tries to tighten things up, because that has, I believe, played a big role in reducing the volume of bid protests. But other than that, I think the rest of the panelists kind of hit on the major points. Thank you.
Thanks very much. Thank you all, and thank you very much to the audience for your great questions. And again, the chat is going to be posted, the slides will be posted, and as soon as the video is processed by Zoom, it takes about an hour or so. I'll be posting the video as well on the program page. Thank you all, and have a wonderful day.